Welcome to our latest webinar. To those of you joining us from around the world, I'm Soffe and I oversee Gleeds International Dispute Advisory Group. I'm a past president of the Chartered Institute of Building and a fellow of the RICS, and I'm on the national panel of the American Arbitration Association, and I'm speaking to you today from Atlanta in the United States. The stats show that the global value of construction disputes grows every year. On our previous webinar, we discussed what causes construction disputes. And in our audience polling, there was a fairly even split between owner-directed changes, inadequate design, unforeseen conditions, non-payment, and unclear contracts. In our experience, all of those things are symptoms of construction disputes rather than causes. Most, if not all, construction disputes are caused by the project taking too long, costing too much, or falling short on quality, either in isolation or more typically as a combination of those things. Today, we're discussing the first of these issues, time. More specifically, we're discussing the common pitfalls encountered by parties when making or indeed defending claims for extension of time. Why is this? Because here's an interesting statistic. The latest project conflict snapshot by a leading consultancy analyzed some 1,600 projects around 100 countries and found that the cumulative delays added up to a staggering 840 years. The average time extension claim was for 16 and a half months. And thinking about the construction period for typical projects, that means a staggering proportion of time is spent in delay on construction projects. Time's a major risk issue in any construction contract. The time to complete the work is the period in which the work must be performed to achieve the outcome. So to manage time risk, a contractor needs to plan and execute the work in the most efficient and productive manner, optimizing all the resources required. The contractor needs to know that the work can be carried out in line with the plan, which in turn means certainty. If he gets that right, the project's much more likely to be on time. But unfortunately, construction projects are inherently uncertain. For example, site conditions, subsurface conditions, adverse weather, changes or interference, or even prevention by the owner, legislative changes by governments, and other external forces such as pandemics, wars, or severe climate events, all impact supply chains, labor, so on and so forth. And now perhaps even a banking crisis over here. In the making. All of these unknowns can add up to a cocktail of uncertainty that's very difficult to manage. So contracts regulate what happens to time in the event that unforeseen events occur. Typically, events that entitle the contractor for extensions of time are either neutral or excusable events like adverse weather, pandemics, or perhaps strikes, or events caused by the employer's team, which are excusable and compensable, such as delayed site access, failure to provide design information, or perhaps a permit that only the employer can obtain. Balanced against these events are delays the contractor causes, called culpable delays. If, for example, it has insufficient labor, poor subcontractor performance, delayed material deliveries, or site procedures have not been properly followed. All this can make some extension of time claims very complex. And so we're examining the subject today where a construction project is typically a network of events, some of which are extension of time events, and some of which are contractor risks. We consider that by having a sensible contract, following it, and taking the right advice at the right time, parties can avoid common pitfalls that can affect their entitlement to claims for extension of time. So in this discussion, we'll be taking views from our international panel about their experiences in what makes for successful extension of time claims and what are the common pitfalls to avoid. So before I introduce today's panelists, we're going to have a poll. So the poll is, how often do your projects complete on time? Never, rarely, sometimes, usually, or always? Be interesting to see what we get back over the next minute or two. This, of course, all plays into the 840 years and the 16.5 months for average delay. So we're getting some results coming in now. Never 14%, rarely 50%, sometimes 26%, and usually 9%. So predominantly, the number is rarely or sometimes. And that would be 76% of projects are rarely or sometimes over time. So that's a lot of claims coming out. Gleeds and Freeths have joined forces to create construction disputes A to Z. This is an initiative where we offer one-stop technical, contractual, and legal advice to clients. We've made available our marketing material on this as an initiative and as a handout for this webinar. So if this webinar raises any issues on your project where you think we could help, or you think you may have need for our services, please don't hesitate to call us at advisory@gleeds.qa or email us at advisory@gleeds.qa. We'll be happy to have a no obligation discussion about any issues you may be facing. Again, that's advisory@gleeds.qa. So let's move on with the main business, and I'll let the speakers introduce themselves. Alex.
Thanks, Chris. Thank you, everybody. It's good to be here. I'm a partner and I specialize in construction and engineering disputes at Freeths. I'm based in the UK, although today I have the pleasure of joining you from Doha in Qatar, where I have been on business this week. My practice is international. I have experience of projects all around the world, and I've worked on a number of construction disputes, projects in the Gulf region, the wider Middle East, and clients based in the USA and Europe. Predominantly, I handle conflict avoidance and dispute resolution, including international arbitration, but I also draft and negotiate contracts for clients and advise them on issues that arise during their projects.
Thank you, Alex. John?
Hi, everyone. I'm John Refaat. I'm covering Gleeds operation in Africa generally. I'm based in Cairo, Egypt. I'm a chartered quant surveyor, member of Chartered Institute of Arbitrators. I'm a board member of the RICS Egypt Advisory Board. I'm having over 20 years of international experience in the field of project and cost management and dispute advisory and resolution on high-profile projects within large developers, cost consultants, and first-tier contractors at senior level within the MENA region.
Thank you, John. And our guest today, Hossam.
Hello, thank you very much for giving me this opportunity. I'm Hossam Kandeel. I'm a project manager at National Bank of Kuwait, Egypt. So I'm based, my work is based in Egypt. However, I'm talking to you from San Francisco, US. I had the pleasure of managing during 21 years of experience. I experienced my experience encompasses construction planning, controls, and risk management for major construction projects and programs, totaling $28 billion in value, spanning 7 countries. I delivered many training sessions, workshops, and implementation projects for building project control teams. The total professionals trained in these activities exceeded 4,800 trainees. I contributed as a technical speaker and presenter in multiple international conferences organized by the Association for Advancement of Cost Engineers, PMI, the Project Management Institute, and the American Society of Civil Engineers, and the Big Five. I've been assigned to several delay claims in 6 countries, including the US, supporting both contractors and employers, developing the determination for claims, and has contributed. I have contributed to 4 witness expert reports from both clients and contractor sides. I'm a certified expert determiner by the Royal Institute of Chartered Surveyors, UK, and I have a pleasure again to join this elite expert panel in such a great webinar. Thank you very much.
Thank you, Hossam, and welcome to our webinar panel today. Just a little bit on questions policy. Please remember to submit your questions in the Q&A box. We'll leave time at the end to answer them as much as we're able. Past experience tells us we won't get to them all, so if you have any questions you'd like to discuss after the webinar, please email us at advisory@gleeds.qa. So on with the panel discussion, and we've got about 5 key questions today that the experts are going to address. The first one being, How do you make a valid extension of time claim a robust one? So Alex, we'll start with you on that one.
Thank you, Chris. Yeah, thank you. I mean, in legal terms, there are a few basic principles to get right. Firstly, there needs to be a legal entitlement to an extension of time. Not all events that cause delay to a project result in an extension of time. And so whether there is an entitlement or not, it depends on what the contract says. Typically, a construction contract will include a clause that sets out a list of events which, if they occur, entitle the contractor to an extension of time, extension of the time for the completion date. And an example is clause 8.5, FIDIC Yellow Book 2017, quite a common form of contract. Now, commonly these events are either things that the employer causes, such as variations to the works, or acts or omissions that hinder or prevent the contractor from carrying out the work in some way, for example, by delaying access to the site. Or they are neutral events, such as exceptionally adverse weather, changes in law, or the discovery of fossils and antiquities. I'm not sure how often that happens, but it's always an extension of time event. Secondly, if there's a notification procedure in the contract, it has to be followed strictly to the letter. If the contract requires extension of time events to be notified in a particular way within a period of time, those requirements must be complied with. Why? Because entitlements can be lost if condition precedents to making a claim are not complied with. Again, for those who are experienced with FIDIC contracts, you will know that the extension of time claims have to be notified in accordance with the claims procedure, which is in clause 20.2, and that procedure is not untypical. So if a party has an entitlement, has complied with the contract procedures for notification, then the final key ingredient to making a robust claim is to demonstrate cause and effect and tell a compelling story. And that will involve pointing to documentary records, to evidence that the event occurred, which entitles the contractor to claim the extension of time, and that the event caused delay to the completion date. And now, dealing with the second of those questions, it may be necessary to show the impact on the schedule, which has been caused by the delaying event. And many claims, in my experience, fall down when the basic ingredients are either missing or they've been poorly executed. Claims that fail to demonstrate cause and effect or fail to identify an entitlement in the contract and which have no basis in fact at all are very unlikely to succeed, at least in a formal process such as arbitration.
Thank you, Alex. That's great stuff. So follow the contract and follow the notice provisions, and don't forget to detail and show cause and effect. John, do you have any comments on that one?
Actually, I agree with Alex. Extension of time claims must establish the cause, effect, and entitlement for additional cost or schedule delays, along with the extent of the damages or destructions. The most common reason why a contractor or a claimant is unable to obtain an extension of time or recover additional cost is that he has insufficient evidences in the form of records to support his claim. Generally, the claimant often argues that as a part of the project, it is constantly dealing with challenges that arise from budget issues, schedules, resource limitations. Records are the last of his priorities in developing the project. But unfortunately, without records, there may be little means of providing your position and proving it to the other party. Even the best management or planned project can encounter disputes without a proper records of activities and events. It is important, therefore, that once you became aware of any issue, that you begin to record the impacts that have arisen from this event. Have one of your planners to work the activities and work your planned activities and study them well, record the decisions that are made or proposed by both parties, and ensure that these are formally communicated. A record of decision taken from both parties will act like a retrospective roadmap. It is these decisions which act as a retrospective roadmap or lack thereof, which may have impacted the project and changed its direction, as well as being used to make a claim. Record of decisions taking can act as a defense of your conduct should the other party believe you are in fault. In summary, I would recommend that to protect yourself, that you need to understand and comply with the contract with regard to notices, as Alex was saying, prepare a program and keep it updated always. Record all the events and matters which appears to cause or have the potential to cause delays. This is a very important thing. Record when changes, variation were carried out on site, because late instructions and others coming at a later claims is important. If you don't have the proper records, you cannot substantiate your case well.
Thank you, John. Some super advice there on necessity of record keeping and having program updates and the contract compliance and establishing cause and effect. Thanks, John. Hossam, how about from your standpoint?
Well, from my standpoint and from where I come from, we are those who are working the back end of the calculations. So looking at the analysis from the back end view, where the quantification process occurs. Quantification means that we are going to calculate number of days and consequently prolongation cost. The most common challenges that face the adequate quantification of extension of time, I mean, getting a number of days, and consequently also the concurrency analysis, which is the most controversial part inside the extension of time itself, are those related to the schedule quality and the level of details. When you don't have a good schedule from the point of view of structuring and building a schedule, the reliability of the results coming out of the schedule in terms of calculating extension of time is in doubt or less. The project schedule normally elaborates through many processes, starting from the strategic requirement to deliverables level, master level, constructability level, and up to the detailed schedule that is subject to the update process that John mentioned. I can say here that the importance of having the updates in the extension of time calculation is far more or in equal footing with having a baseline, and in order to have or enhance the quality of
I think we may have lost Hossam there. Seems to have frozen as in San Francisco in May. So let's see if he comes back. But anyways, it's some technical delay analysis insight there from Hossam, along with the need to sort through concurrency issues. And as he's normally looking at schedules from the back end as well, and establishing the essence of a good schedule. And interesting to see he's using the term schedule and not program because he's in San Francisco. So he flips out like I have to. So let's go to the second question, because I think Hossam.
I'm back.
Yeah, Hossam,
Yeah,
we lost
yes.
you for the tail end there. Where you came in. You want to continue?
Yeah, if you can give me a minute, just maybe there is a disturbance in the network or something. I can just say that I reached the point that when it comes to EAT claim quantification of the delay and concurrency, it is totally dependent on the schedule, baseline update quality, detailed,
Yeah.
and most of all the availability. If you don't have these schedules as part of the claim itself, it will challenge the process of having a good claim. The recommended most of the references are talking about extension of time claims and the way of quantification of the extension of time claims, like the SCL delay and disruption protocol and the RP. Gave attention to checking the schedule themselves, the available material to calculate the extension of time. The RP, the recommended practice coming from the Association for Advanced Cost Engineering, dedicated a complete chapter articulating the validation protocol of schedules used in the extension of time, the baseline and the update and the asphalt. They defined the program as the source of the data, as the source of information that is important to get an adequate extension of time quantification and reliable results in terms of quantification itself. I'm sorry for the interruption again, and I'm back with you.
No worry. Thank you for that, Hossam, and for battling through the IT issues. So you can see the insight on technical delay analysis from Hossam there, along with the need to sort through concurrency issues. So with that, we're going to move on to the second question. And that would be, if a contractor is granted an extension of time, can it automatically claim prolongation costs? Firstly, Alex.
Thank you, Chris. In many ways, the short answer, which is no, that's a common misconception. Time and money claims are entirely separate. And even though they may and commonly do arise from the same event, the key word being automatic here, of course, but just because the contractor receives the extension of time doesn't automatically mean it's entitled to an additional payment. So on the occurrence of an event such as a variation, which typically entitles the contractor to both an extension of time and an additional payment, the contractor is in effect making two separate claims. One is for the time impact associated with the event, i.e. variation, and the other is for the cost impact. The point is that these impacts are separate and the criteria for establishing those claims are different. So time does not equal money in this case. When referring to an extension of time, what we're doing is we're referring to a cause that excuses the contractor's breach of its obligation to complete the work by a particular date. It's a breach of contract. Where the contractor doesn't have an excusing cause, so where there is no entitlement to an extension of time, then the contractor is in a breach of contract. And the employer's remedy for that is typically the right to deduct, withhold, or claim liquidated damages for delay. So technically, the only real money effect of an extension of time in and of itself is to relieve the contractor from its liability to pay liquidated damages. Now, compensation for financial losses that the contractor suffers as a result of a delaying event is a separate matter. Contracts that have events that entitle contractors to extension of time and events that entitle contractors to additional payment are very common, but these things are separated. And as I said, some events, particularly where the result is an employer's action or breach of the contract by the employer, result in both entitlements. So, for example, variation and acts of prevention commonly entitle contractors to claim extension of time and to claim financial compensation for loss and expense. So in legal terms, parties shouldn't be fooled into thinking that just because an entitlement to an extension of time exists, or just because an extension of time has been awarded, this automatically gives right to an additional payment. Parties need to, in essence, make two different claims, one for the extension of time and one for the additional payment, provided that the contract permits the contractor to do both.
Thank you, Alex. So it's a firm no there from you on whether or not the extension of time claims automatically come with some costs. Also interested to note that time and money are separate claims, even though they might be related to the same events. Hossam, what's your take on that one?
Yeah, not much, but I totally agree with Alex, and I totally agree with the term Alex used also, common misconception. The entitlement to an extension of time doesn't automatically entitle the contractor to prolongation cost. Actually, sometimes, in some cases, in some practical contractual context, having a delay event doesn't grant the contractor to earn the extension of time in the first place. But anyways, this is a special case. The key word here is concurrency. When two or more causes of delay attributed to both parties occurring at the same time or the same interval, depending on the type of concurrency we are using, at that time, controversial discussion of entitlement to to extension of time commences. However, it is less controversial regarding prolongation cost. Most references are referring or linking the compensability to not having concurrent delay. So this is my input in brief in this question.
Thank you, Hossam. So concurrency and multiple causes introducing some more complexity to the situation.
Yeah, exactly.
And just tapping into what Alex said, of course, you know, an extension of time relieves the contractor from having to pay, if it's an excusable extension of time, relieves the contractor from having to pay liquidated damages. So that's another interesting point that came out there. John, what about your take on that?
Agreement with both Alex and Hossam. Though prolongation costs are often seen as a financial side of an extension of time claim, there is no automatic entitlement to loss and expense or damage event, even if a right to an extension of time is established. In other words, as Alex said, time doesn't always equal money. it is also important to remember that the analysis necessary to establish the contractor entitlement to an extension of time is different than the one needed to establish his entitlement to the prolongation cost. When claiming prolongation costs, the contractor must ensure that his claim includes sufficient information to enable the amount of losses incurred or expenses to be ascertained. Detailed submission within comprehensive supporting information should be provided by a contractor if possible. This will facilitate the analysis of quantum at a later stage. Prolongation cost claim by the contractor must be linked to the alleged employer delays. Global claim which assume a link between cost and employer risk events should be avoided. The contractor must demonstrate that the overspend to the client result of the employer risk delay analysis is well connected.
Thank you, John. So time absolutely doesn't necessarily equal money, and also some quantum discussion creeping into the narrative there. So on to the third question then. How does a contractor go about establishing an extension of time claim? Some basics there. Alex?
Yeah, thanks, Chris. So as I mentioned in my answer to the first question, the essential ingredients of entitlement, notice, and causation all need to be covered in the claim. And assuming those ingredients are there, essentially the contractor needs to prove on the basis of the burden of proof. So if it's English law, it's on the balance of probabilities that the event complained of occurred and it's entitled the contractor to an extension of time. So I should also add that where the contractor has caused or contributed to the delay in question, typically that means it is not entitled to an extension of time. And most contracts expressly say that. Now, causation is typically the most difficult element to establish. Causation means showing that the event caused delay to the completion date. And note that that is critical delay because it is delayed to items of work or activities that are on the critical path. Although sometimes contracts will enable extensions of time to be granted to delays for other key dates, but it has to actually say that. And if we take the Society of Construction Law's delay and disruption protocol, the critical path is defined as the longest sequence of activities through a project from start to finish, the sum of whose duration determines the overall project duration. And typically only about 20% of the scheduled activities are on the critical path. So many events may cause delay to non-critical activities that are not on the critical path, but that doesn't mean they give rise to an extension of time. That only occurs if those non-critical activities mount up or are compiled to the point where they become critical. So to establish that an event caused critical delay, the party needs to show that the critical path of the project and explain the events that cause delay to the critical path. And in most cases, parties will rely upon expert evidence from a scheduled delay expert to conduct that analysis, and lawyers will establish which party was responsible for the events that caused the delay.
That's great there. So the importance of the critical path coming into play and the ingredients of entitlement, notice of and causation are so important with any claim. John?
Yeah, Chris. I would say that it is important to read and understand the contract and know the terms that govern an extension of time claims. These terms may require notices to be sent, as we said before, within a certain time frame. And if notices are not sent, you may lose your right to file a claim. You should also know the valid reasons for filing a claim. I have seen in my experience a lot of notices sent for, I would say, unnecessary claim or illegitimate claims because one part did not actually read and gone through the reason why he should claim. There are also generally two notices that need to be sent for an extension of time claim. First, the notice of delay and the extension of time claim itself. People think that he will, or claimant thinks they can send the extension of time along with the notice. This is two separate things. A notice of delay is simple. It can be sent in form of a letter and email, depending on the communication agreement, communication protocol within the agreement. And it explains the event that has occurred and how long of a delay is expected. The extension claim is sent once all costs have been determined and the events have been understood. So you can see what is the impact on or effect on the project itself. Submitting an extension of time claim requires documentation of the cause and of the delay, its effect on the project, and any costs related to it. Contractors should include photos, revised schedules, emails, weather reports, or any other evidence to support their claim of delay and cost. It is often said that the one with the most documents wins. This is correct. It is very true when you are filing an extension of time claim in particular. Keeping track of potential schedules allow you to show the effects of delays on the critical path of the project. This evidence is important when submitting an extension of time claim. Scheduling software easily and clearly shows delays and how they affect the overall schedule. In the course of a long delay or a continuing effect delay, more than one extension of time may need to be submitted. If this is the case, it is important to continue communicating with the employer and let them know the effect of this continuing delay and whether there is further claims to be filed or it's just only one global claim. So this is important because I have seen, especially in the ongoing effect of the COVID and other situations, that people cannot determine the final impact of this claim at some point, but they need to clearly communicate this to their employer because sometimes they give a global compensation without understanding that still further claims coming their way.
Excellent, John. So following the requirements for notices and that record keeping and documentation absolutely essential to support a good claim. Hossam, what's your answer to that one?
I will come again from the back end side or the very big pool of information that we are diving in order to get a quantification at the end of the day. Because of course I admire the importance of the entitlement and substantiation, but after very long record keeping and record presenting and doing substantiation for each event, you have at the end of the day to give a total number of days, a total number of costs. So I'm going to talk about the total number of days here in the context of this question. After having the entitlement, the merit part done, and from the forensic planning standpoint, there are 3 processes to deal with delay events in process to develop an extension of time claim in terms of quantification. First, identify, and my esteemed colleagues, John and Alex covered this, identifying and collecting the delay. But from my point of view, with 2 main approaches, the cause-based approach of identifying and collecting delays and effect-based approach, in this process, the nature of delay events may drive the analyst to choose the basic method he's going to use. Is he going to go, or is she going to use observational or model method? At the end of the process, the contractor, the claimant, shall have a list of delay events with the proper substantiation. And from this point, the analyst can start with the second process, which is the quantification of delay in 2 main moods, which are retrospective, the actual mood, if we have events that are finished and done, and we can hindsight the records associated with these events, or the prospective mood or the forecasted mood, the blind side, which is related to events that are going to occur, or we have the event in place, but the discrete work of the event is not occurring yet or has not occurred yet. This shall determine whether the event records are actual or estimated in this quantification of delay. And then we come to the last process, which is dealing with the schedules themselves, or if we are going to use the FEDIC term, the program, the process is quantifying delay duration, which involves calculating the impact using the available schedules, programs, and documents. There are 2 main methods of calculating the delay duration. Variance methods, which is variance method, which is related to schedules, and it needs a good planner, or good forensic planner to implement a proper way or adequate way to calculate the extension of time. Or there is another method relying on the record itself. So they are not going to review the programs. And this is not the common case in complicated projects, because I'm seeing a question related to unavailability of schedule and of schedules, and what can we do if we have this case. But in general, these are the three processes to deal with the events in order to come at the end with a number that we are going to negotiate or defend, or going to entitle the contractor to this number of days, consequently prolongation costs, if any. Thank you.
Thank you, Hossam. Some good insight there into the identification and quantification processes that planners or schedule analysts will use. Now, all of that segues very nicely into our next question, which is somewhat tongue-in-cheek. Do I need a schedule expert or schedule delay expert to prove an entitlement for an extension of time? Do I always need one? Alex?
Yeah, thanks, Chris. With apologies to Hossam, strictly speaking, no. Schedule delay experts are not necessary to prove an entitlement to extension of time. And the reason is because whether a particular event occurred and whether it caused delay, it's just a question of fact. So in theory, if parties to contracts in construction projects had fully accurate, comprehensive records of absolutely everything that ever occurred on the project, which was all fully aligned to the contemporaneous schedule, then the delay and any extension of time claim could be demonstrated purely on the facts, because all the data is already there. And now the big problem with that, of course, is that parties generally don't work like that. And they don't keep those type of records because of the demands of the project, if nothing else. And so the quality of documentary records held by clients is often extremely variable. And so this is where schedule delay experts come in, because the schedule delay expert will review the schedules, if there are any, review the relevant contemporaneous documents in order to establish the critical path through the project and identify the events that cause delay to the critical path. And there are various methods of doing this, and Hossam is more qualified than me to explain them, but they all rely on the expert being provided with some form of evidence. And the better the documentary records you have, the more real and the less theoretical the delay analysis will be. So it's always important for parties to keep as thorough and as comprehensive and as accurate written records as they can. As John said, the party with the most records generally wins. It's not a bad rule of thumb. And from a lawyer's point of view, a good schedule delay expert can be invaluable, because there's a great deal of professional judgment that is involved in delay analysis when interpreting the facts from the various records. So it's important that the delay expert knows and understands how the project is undertaken and managed, because they're not just a planner or a scheduler, they're exercising their professional judgment. And so that's why it's important to find a good expert. Again, another way to win a case is to have a better expert than the opponent. It's just basic facts. So clients should understand that delay experts are not claims writers. They're not really interested in who was responsible for what. What they are getting at is what was the critical path and what events caused the delay. The question of who is responsible is for us lawyers to examine in relation to the evidence. The delay experts are just interested in identifying what caused the delay and how much delay.
Thank you, Alex. So John, what do you say to that?
Actually, I'm in agreement with Alex, but despite that a schedule delay expert existence is not mandated to prove an entitlement of extension of time. However, to be fair to the delay expert, to provide a relevant and credible delay analysis, it is crucial that the most appropriate approach is adopted. And if there is no clear delay analysis method stated within the contract, the delay expert existence help in identifying the event that occurred, considering certain issues such as concurrent delay, pacing delays, delay mitigations, acceleration, etc., and selecting the appropriate delay analysis approach to be adopted in this case. In case that dispute escalated, the existence also of an independent delay expert assists the court or tribunal to understand what happened, when, and why. So in fairness to the delay experts, including Hossam, their existence, despite being not mandated, however, it is essential from my point of view.
Thank you, John. Hossam, where do you stand on that? I think you're muted.
Yeah, I don't have much to say to this, but no need to apologize, Alex. Yes, it is a no at the beginning. The delay expert rule actually commences after clearing the entitlement. Maybe if there is a dispute in the entitlement and it goes to a form of dispute resolution up to the arbitration, the daily expert may do some what-if scenarios, just slicing and dicing between the events in order to say, okay, if this is entitled, but this will give us a real half time to give so much scenarios for the sake of dispute resolution. But again, I'm in a complete agreement with Alex and with John also that no, it is not a mandatory to have a delay expert at the entitlement stage, but it's of course a mandatory to have him in the process when you want to know how much time are you going to extend and what is also. I will take just one of John's points and highlight on this. You need him also to give a clear input in the method you are going to adopt to analyze the delay, because this created, in my experience, and I've seen a lot of issues arising from not having an agreement on the method. So the contractor uses a method and the consultant or the engineer is seeing that this method is not appropriate. However, the contract is silent in this point, but this where the delay expert role comes and his existence is mandatory. But again, I agree with Alex completely that actually it's a disturbance to have a delay expert in the entitlement process. He should start after the entitlement process.
Thank you, Hossam. So the experts agree there that I think really this is a matter of complexity. Thinking of simple suspension of work claims or delayed start, or perhaps just a number of weather days, are both usually very simple to assess. So you wouldn't necessarily need an expert planner or delay analyst for that. The more complex the issues, or a single issue, the more reason to engage, I think, a schedule expert. And of course, always the parties can agree on a number of days, and they can agree on quantum, even if they're in different fields, in order to move a dispute forward to a settlement mode. So there are always options.
Yeah.
So So let's go on to the fifth question. So this is an interesting one. It crops up sometimes. What's meant by time at large? We hear that term often throughout our careers. Alex?
Yeah, thanks, Chris. I mean, time at large is a phrase that is somewhat overused because it describes relatively rare circumstances under the law. And those circumstances are where a contract requires a party to complete the work by a fixed date, but the contract contains no mechanism for extending time. So principle is that the employer cannot on one hand insist that the contractor completes the work by the agreed fixed date for doing that, but also, for example, carry out some act or omission that prevents the contractor from doing so. And that's known as the prevention principle. I think someone had a question about that. And so the fact that there is no mechanism for fixing a new completion date is said to put time at large, which almost means what happens about time. And so the effect of time becoming at large is that the contractor's obligation to complete the work by the fixed date that was agreed is replaced by an obligation to complete the work within a reasonable time. What is a reasonable time depends on the circumstances of that particular project. The other impact of a time at large situation is that it will have the effect of rendering any liquidated damages unenforceable, because the employer cannot benefit from its own breach. So when reviewing proposed contracts, it's important to check that where there are liquidated damages, that there is also an extension of time mechanism. That it happens more often than you might think, that those two things aren't always there. And because liquidated damages won't work without the extension of time. Bad for the employer because it can't have its liquidated damages, bad for the contractor because its delay liability is not capped. And I just also wanted to mention another phrase that is a source of confusion, which is time is of the essence. Now that wording has the effect of making provisions that concern time in a contract conditions of that contract. And breach of a condition discharges the other party from its obligations to perform the contract. So a contract in which time is of the essence permits the injured party to terminate it and claim damages where the other party has not delivered the goods or services on time. Now, for that quite simple reason, it's commonly not included in a construction contract because those contracts generally have obligations to complete the work by a particular date, an extension of time mechanism, and liquidated damages, which are subject to an overall cap. And that is all more benefit generally to the employer than having the right to terminate the contract for any lateness. There's not a lot of point having a half-finished project. It's better off to have all those mechanisms that we normally expect to see.
Thank you, Alex. Good legal insight there into time at large, and time is of the essence. Hossam,
Yeah,
come across that?
Yeah, actually, I'm facing now a situation in one of my projects that time is at large. In simple way, if the project encountered a time at large status, this means that there is no enforceable date of completion. We are standing somewhere in the project, and no one can answer when are we going to finish. So it's for me, it's a disaster for both parties. The client cannot know when he's going to, the company is going to utilize the project and put it in operation. And actually the contractor is in a disaster too, because he doesn't know when he's going to release his resources and reutilize his resources somewhere else, or stop the overhead being paid. Most construction contracts require the contractor to complete the works by the specific date. If the contractor fails to do so, and unless the terms of the contract entitle it to claim an extension of the completion date in respect of the causes of the delay, it will usually be liable to pay liquidated damages to the employer, which will be stopped by having a notice of claim or something. We at this stage we cannot neither extend the program, neither extend the time for completion, nor apply liquidated damages. So in my view and from my experience, having a time at large is a very negative thing on the project. Of course, this goes without saying, but having a time at large is one of the results of many open extension of time claims. If in some clients' culture that they are ignoring extension of time, or just prolonging replying to the extension of time, or prolonging resolving the extension of time issues, even if they are in a certain that they caused these delays at a certain time, the backfire of such behavior is having a time at large. Time at large usually means that there is no enforceable date of project completion. Thank you.
Thank you, Hossam. It's interesting your experience there on how a time at large often accrues through lack of administration or following the contract criteria to start with on extension of time issues. So, and the unenforceable implications of time at large. And I think Alex said not a benefit to anybody really. So, John, do you have any experience of time at large?
I do, Chris, and actually I think its response to this question was covered very well by both Alex and Hossam. To simplify, time at large is a term used to indicate that the duty to complete the works within a certain date is lost. Accordingly, there is no enforceable date for completion, and in this situation, the contractor is no longer bounded by the original completion date and the liquidated damage regime, and only has an implied obligation to complete the work within a reasonable time frame.
Thank you, John. And with that, those 5 questions and some terrific answers and insight there from the panel, we'll move on. We've got about another 8 to 10 minutes. So we'll move on to questions that have been mailed in and questions that have come in on the Q&A. So here's one. If a contractor has a valid and compensable extension of time, can cost inflation or escalation also be added to the costs? And also, can head office overhead be claimed? And that, of course, is coming in with ICLA, Hudson, Ebden formulae, because he could have used his management and his resources elsewhere to pay for his overheads, generally his ongoing overheads, and make a profit on another project. So what's your take on that one, Alex?
Yeah, I mean, I defer to the quantum experts on the formulae. And then this is really about the loss and expense claim, not really the extension of time claim. But yeah, typically as part of the prolongation cost, you will see a claim for lost office overheads, and the counter argument to that claim is always, well, exactly what you said, Chris. Well, those people could have been doing something else elsewhere in head office, and so those claims are difficult to establish, I would say, but they're not really a component of an extension of time claim.
So Hossam, where are you on that? Thank you, Alex. You come across those claims for extended overhead?
Exactly. And I'm in totally agreement with Alex. I have nothing more to say. It's not an extension of time claims. And the simple answer is, yeah, you can utilize them if your company is not opened and operating for our project only. You can just utilize them elsewhere. So in simple, yes, it's not an extension of time claim.
Thank you for that. And John, as our quantum expert, this is probably more of a quantum question than anything.
Yeah. Okay, okay, Chris, to split, generally, there is no relation between an extension of time claim and escalation claims, because escalation claims or change in prices can happen anytime without impacting the duration of the project. So this is two separate claims. We have recently seen across the world, I would say, claims for changes in prices, especially when COVID started to impact the shipment duration and supply chain and other things, but they are not related to extension of time. And when it's come to the part related to the head office overhead, to prove the losses in head office overhead needs to get back to how it's calculated. Head office overheads generally calculated based on the impact of the turnover. So to get actually compensated, the contractor need to prove and substantiate that he really lost monies due to this one, means he's opening all his books to the quantum expert to do it. And I have never seen a contractor who was able to substantiate it properly, because he will not open his books to show us how much he earned and how much he gains.
Yes, understood. Thank you for that. I mean, it also plays into a big topic over here, a thing called no damages for delay clauses, which are valid in some states in the US and not in others, where lawyers are tried to exempt contractors from claiming these head office damages, if you like. So with that, let's move on to another question we have here from the Q&A from Mustafa. Don't know where you are, Mustafa, but should the employer review the provided project schedule by the contractor in full details and approve it, or can the employer stick only to the contract milestones in that case? Can the contractor rely on his submitted schedule in his claim in that case? Hossam, you want to take a stab at that one?
Yeah, of course. Yes, the answer, yes. Yeah. How, if you are going to go and rely only on the milestones of the contract, so what's the use of the schedule? The extension of time thing is how we impact the critical path, and how the critical path got impacted, and consequently, who are the cause of the delay, and how can we attribute the cause of delay to these things, to the delay in the critical paths. So yes, the employer with his technical team, I don't know whether the employer is doing this through a PMC, a project management consultant, or having an engineer doing both the technical and the management things. But yes, the employer should review in details the project baseline schedule submitted at the beginning for the sake of approval and acceptance, and regardless the contractual clause that determines the ownership of the float or something. In addition to this, not only the baseline that is required to be reviewed, but also the updates also are required to be reviewed. Not for approval, maybe because the contractor, if there's nothing prevent this in the contract in the first place, the contractor is the major owner of the site. So the contractor may elect to do some kind of acceptable out of sequence, not unacceptable acceptable out of sequence, changing the sequence in order to mitigate some site circumstances, unforeseen circumstances. And the update is reflecting the image of the site at the contemporaneous status. So once we have an extension of time and we have an event at a certain state, we need to refer to this, the status of the site at this event or at this point of time. And this cannot be done with the contractual milestone listed in the contract. This must be done through schedules and through also good quality schedules, not only schedule or master's level schedule, through good quality schedule. And to my experience, and this is the last statement I'm going to say in this question, in my experience, 90% of the quantification problems coming from 90+% coming from and making disagreements in the term of construction of extension of time are coming from bad quality or less quality programs we are schedules we have during the project. And unfortunately, sometimes we are using a delay expert coming from the third party coming from the outside. He comes at the end of the project, so he cannot do anything about all the schedule for accumulated through 1 year or 2 years of performance.
Yeah, understood. Thank you, Hossam, for that. There's an interesting legal question that just came in from Kareem Zaran. I hope I said that right. From a legal standpoint or viewpoint, can the contractor in any case reject the deduction payment or payment of liquidated damages or deduction for liquidated damages because he hasn't affected the client's profit, for example? Alex, you want to take a try at that one?
Yeah, I mean, it depends on the jurisdiction. So it depends on what law applies. But if that was English law, the answer is a big no. The liquidated damages are agreed compensation for the contractor's breach of contract, i.e. failure to complete the work on time. So if the contractor fails, the employer may levy the liquidated damages irrespective of the amount, unless they are a penalty, which is a fairly limited set of circumstances under English law. But there are civil jurisdictions that could enable liquidated damages to be challenged. Whether they can be challenged because they don't affect the client's profit, I'm not convinced by the argument, because that's irrelevant as to whether the project is late or not.
And John, why did you move into dispute advisory services? Obviously, I think you're quantity surveyor trained, working for Gleeds. What attracted you to this field?
I started I'm actually a civil engineer, Chris.
Sorry. Sorry for the insult.
Yeah, and I have developed my skills over years because I started my career as an estimator. So I became a quantity surveyor. After like 15+ years, I was attracted. I have lived and worked in Dubai during the financial crisis in 2008, 2009. So basically, it attracted my attention, the issue of disputes and dispute advisory and claimant experts. And so I start to get interest in this one. I start to move towards this slightly. And when I joined Gleeds, there was a couple of movement, especially with changes in law, change in legislation, introduction of new things. And I have the pleasure to accompany one of the quantum experts from Gleeds itself, from the dispute advisory, and I learned from him. So I say I learned from the best people here. And this is what attracted my attention and moved me to quantum. Plus, they get paid more, actually.
Wow, that's very good. Very good reason there. Thank you, John. Hossam, you know what's coming. Why did you become an expert in delay analyses? You're muted, I think.
Yeah, as usual, muted. Sorry. Actually, I was driven at the first place to go as a delay expert. I started my career as a planning and scheduling engineer, and then I moved forward to project controls and risk management. And then I found it challenging when in 2009 I got a case with complicated TIA at that time. So moving forward, I found out that this is one of the most controversial part in the industry, and I love controversial ones. I love going to controversial things and solving some riddles. And the thing is, the funny thing with if I may say funny, the funny thing about being a forensic analyst is that anything can go. Anything can go. Really, if you can refer your work to a certain reference and do a coherent substantiation, let's say, for what you are doing, anything goes. So when it comes to this point, yeah, this is the core of controversy. So that's why I'm in love with the with forensic.
All right. Well,
analysis,
look,
project planning.
a special thank you
Yeah,
for
most welcome.
joining us today as our external panelist. And I know that you're up early in the morning in San Francisco. So just
7
to
a.m.
everybody, thank you all for attending.
Most welcome.
If anything we discussed today raises any questions or concerns on your projects, please contact us or email us at advisory@gleeds.qa to see if we can help, or don't forget to contact Alex or me or John directly. We very much hope that this session has been valuable to the attendees today, and thank you all for watching the webinar. Thank you and goodbye from Atlanta, Qatar, London, Cairo, and San Francisco.
Yeah.
Stay well. And
Thanks,
safe.
everybody.
Thanks,
Thank you.
everyone.
Bye-bye.
Have a good day. Bye bye.
Bye, everybody.